Okay, so the next panel is how to protect your art. So I want to bring on some amazing experts in this regard. We have, who do we have first? We have Ilya Krasnersky. Ilya, how are you, sir? We have Logan Hicks, the amazing artist, Logan Hicks. And we have Joshua Wattles. Deviant Art, sir, good to see you. Thank you for coming. So, how many people here have heard of Deviant Art? All right, yeah. Well, Joshua was the advisor-in-chief for Deviant Art for many years. Were you officially a co-founder, or?
I'm not, and I don't qualify as a co-founder.
Oh, okay.
But I was there from the beginning.
There from the beginning, excellent. We have Logan Hicks with us, in from New York. Hello. And Ilya Krasnersky. Thanks, guys. So let's jump right into this, because this is an important topic for so many folks here today. You know, we are in the business of producing original intellectual property as artists, as creators. We want to protect our IP as we can, when we make it. We want to make sure we don't get ripped off. And these are times when I think a lot of artists are getting ripped off. A lot of things are happening out there. I mean, Logan, as an artist, what are some of the struggles you've had when it comes to protecting your art?
Well, when just simply being an artist, as you start getting older and taking it, serious, more like as a career, it's uncomfortable to transition sometimes thinking about your work in a business environment. But for me, the fact is, like, anything I do inside my studio with the doors closed is art. Anything that leaves my studio and then enters into like the commerce section where people are buying it or commissioning it or whatever else, it's just business. At the end of the day, as soul draining as it is to think of art as this, but like it's a luxury good for people. And so once you kind of go into that realm, you then need to do all the protections that you would if you were any other traditional business, one of which is protecting your IP, making sure people don't rip you off, and so on and so on. And it's kind of like as you become when you're younger, it's like it's the shit if you have someone that, say, like, is a bartender that can hook you up with free drinks. As you start getting older and you're an adult, it then becomes a shit like if you have like a really good lawyer, car mechanic, and plumber or something. And so for me, it was just, it's absolutely essential that you have someone that understands the law, understands what protections you have, so that you don't do the take a baseball bat, go to the gallery, and insist on getting paid, which may have been the younger version of me. But courtesy of this gentleman here, I am now older and hopefully wiser for protecting stuff. And rather than stress out and post like furious messages on Instagram and Facebook about fuck this company and they screwed me over and fuck these guys, and I can turn around and send an email or give a call and be like, hey, this is happening, what options do I have, what do I do from here, should I say anything, and so on. And I just think, like, as an artist, it's essential that you kind of know your rights and that you don't let emotion dictate your business path.
So out of every 10 artists, how many artists are an adult or a child when it comes to their copyright? It feels like, in my experience anyway, there's a lot of opportunity for growth in this regard.
Yeah, I think look, anytime someone rips you off and you see your shit in like an ad campaign, I think that the first impulse is to tear them a new one on Instagram. And I think that, but I think a lot of people are just in it for the sympathy sometimes. If you're really a true businessman and you want or businesswoman, and you want to right a wrong, it sucks, but like they gotta pay, and you have to go through this long process and whatever else. But I think that a lot of people just post a lot of this, like, this person's copying me because they want the likes and the comments, and like, yeah, you're right, fuck that guy. And it as reaffirming as that may be that you're for your thoughts, like, it doesn't do a shit bit of good. So
that's 2/3 of our traffic on DeviantArt.
So Ilya, when you and I were together in New York a few weeks ago chatting, you said something I thought was really interesting because you said that you try to encourage your artist clients to make filing for copyright protection part of their process, right? Could you talk a little bit about that? I mean, how's that? I mean, does that resonate with artists? Unpack that for us a little bit.
Yeah. So it does. I think it does resonate with a lot of artists, but I think so. When you're making art, if you're an artist, you're what you want to be doing is you want to be making art, and you don't necessarily, and maybe you want to be thinking about like the business. Maybe that's as far as you go. You want to think about, well, obviously, how do I make money? How do I make a living doing this? How do I keep this from just sort of being a hobby? How do I keep this going? How do I make a career? That's, so you have the artist side, you have the business side, but then there's sort of also the legal side, and I think that part is really hard to broach because there's a lot of gatekeeping in that, right? There's a lot of bad information or misinformation online. A lot of lawyers are, let's face it, bad. They're bad at their jobs, and you call them as an artist, and they want like $10,000 just to even talk to you about something. So there's all these gates. They might give you bad advice. They might, because law is a hustle too, and it's like you might have your specialty, but then somebody, it might not be art law, it might not be copyright, but somebody calls you and you're thinking, oh, here's work, so I'll take this on, but maybe you don't know what you're doing. There's some lawyers that do that sort of thing, but understanding your rights when you're making work, understanding that sort of third component, which is the legal aspect of what you can do, what other people can do, that's important to internalize as part of being a professional working artist. And one of the things that you can do, obviously, to protect your work, one of the things we're going to be talking about is registering your copyrights. But I think what you want to do is, just as you work on the other routines of being an artist, right? You figure out like, okay, where am I going to work? What are the hours I'm going to work? How am I going to, have a life that's not just in the studio all the time? I think you have to apply that same sort of thinking to, taking the time to register your copyrights, protect them. Not sort of just leave it until later. And that's sort of what I mean about making it part of your process. Like figure out, okay, what the thing that I advise people to do is, register at the end of every month or at the end of every 2 months, take stock of the work that you've created over this past couple months, set aside a couple hours. Each time you register your stuff, it's going to get easier. You're going to figure out how to do it faster. You're going to get to a point where you can do it in 10 minutes. The first time around is going to be a little long because it's confusing and it's a government website and all that. But make it part of your process so that at the end of every month, at the end of every 2 months, you're doing this, and just make that part of the process of creating the work.
And also, it's important to note that you don't need a lawyer to register your stuff. You can register it yourself. It costs $35. It takes 10 minutes. So for me, when I do a mural, even though I sign the mural, my piece isn't done until I sign the thing registering it, because I know that's kind of that's sort of the lock that goes onto the mural to make sure that it doesn't extend beyond that. So you don't need a lawyer. You don't need someone really even sitting there giving you a lengthy explanation. You can take 30 minutes, read it over, and from that point forward, it's easy as hell to register stuff.
Josh, what's the downside for not filing copyright, and what's the upside for filing?
Well, the downside and the upside are the same. So if you register your copyright, you are then entitled to bring litigation around your copyright. So if you fail to register, you actually can't even initiate a lawsuit. You can threaten, you can cajole, you can do all kinds of other things, but you can't actually walk into a courtroom. That's one. Two, if you fail to register within 3 months of publishing the work, and publishing is a sort of technical term, you lose the opportunity of claiming statutory damages. So back in the early days of downloading, when the RIAA decided to make everybody's life a misery and make everyone's grandmother feel like they were going to die, and then actually proceeded to bring some lawsuits that did result in some grandmothers getting very sick. In any event, back in those days, you would get a letter that would say, for every single song you downloaded, it's going to be $150,000, which is a sort of a unique thing in copyright. So in most situations, when someone does you wrong, what you get to recover is your injury or their profits. But the copyright law is has a paternalistic component to it, or maternalistic, or gender nonspecific ist thing, where the notion is most artists' work don't have that high of a value, and so, or most authors' works don't have that high of a value, so they're not going to actually be able to go to court and stop someone from stealing from them because they're not going to have the incentive in terms of recovery. And so they invented this thing called statutory damages so that you get at least that amount of money. So for a non-willful infringement, you can get between $750 and $30,000 for each infringement. And for willful infringement, the number goes up to $150,000. $150,000 is very rarely reached, as is the $30,000 very rarely reached. But at least it's a nice intimidator. For a naive lawyer, it might actually be an incentive. The other thing you can recover if you register within 3 months of publication is attorney's fees. That's like very important. So there have been cases where the attorney's fees have been in excess of $10 million. I actually handled a matter that went to the Supreme Court, which at the time was the largest attorney's fee given in a defense case of $1.2 million. That's a very important thing because affording a lawyer is sometimes difficult, and if the lawyer sees that your case is great, and if you registered within 3 months, you have the opportunity of getting your lawyer essentially for free, and a good one, too. I sort of disagree with the idea that there are a lot of bad lawyers out there, so you have to be careful. The easiest way for you to make sure you don't get a bad lawyer is to ask the lawyer if they've ever represented other artists and talk to those artists, and also look them up. Every lawyer of any decency out there has something on the web, and look them up and see if they have a background in copyright or in the arts. And you can do that. Same diligence you would use to find out if, another provider of services to you knows what they're talking about, Right. So yeah, the upside is you get those two things. The downside is you don't.
But I'm a struggling artist. I mean, $35 doesn't sound like a lot of money, but you know what? To me, it is. So what?
Well, so it actually isn't because, as Logan, I'm sure you do this. Most artists register groups, so you can register a whole series of works for $35.
Also, I think the whole I don't have money thing. Look, anyone can come up with $35. People spend that at a bar, And for me, there's certain things that really suck after you make the art, like shipping the art, insuring the art, photographing the art, making sure that you have documentation of it, like having to go and register the work. All that stuff sucks, but it's just kind of part of it. And at a certain point, you need to figure out if you want to be like a professional artist or if you just want to be a hobby artist. And if you want to be a hobby artist, that's fine. You don't need to do a lot of that stuff. But
no, registration is going to be way cheaper than shipping.
Yeah, but I'm saying
I'm serious.
But I'm saying all of it sucks. And you just got to find, if you want to go the professional route, you just got to find the money.
It's sort of, maybe this is an oversimplification or maybe it's just wrong, but as I'm listening to you guys, I'm thinking of this as like an insurance policy. And I don't take that literally, but if I'm protecting my work by filing for copyright protection, somehow that's a hedge, it protects me.
I think one of the things that lay people don't get about registration and what's so great about it for you is in any kind of situation where another artist you feel has taken your work, the first thing you're gonna have to establish is that your work existed before their work did. And how are you gonna do that, right? And if it's just you sitting in a chair in a deposition with a video camera on you saying, I made this on March 1st, 1952, it's not very compelling. and what you're going to want evidence of it. And so if you are a practicing artist, one of the best ways to establish evidence of the fact of making the work as of a specific date is registering it for copyright. And a copy of the work will be on deposit with the Copyright Office, and your lawyer will be able to go find it, either to defend you, which can be important, particularly in the world of appropriation art. It's very important to be able to defend that you were the originator, or when you're acting to stop someone from using your work. It establishes a date. You plant a flag. It's a great way to do it.
Yeah, Ilya, thank you, Josh. I know you had said to me one time, you said you sort of have a list of do's and don'ts when it comes to copyright protection. Like, what's the list?
Yeah, so, excuse me. So I think I have lots of do's and don'ts, but I have the do's and don'ts for, when you found out, you think your work has been stolen, there's a do's and don'ts of registering your work beforehand. Are we talking about the former or the latter? Or?
I forget exactly what context it was when you and I were chatting about this, but I think because of all of your years of work with artists, you sort of got this little mental list of things.
So without taking up too much time here, going back to something Logan started with here, if you find out, so let's say you found out, you think that your work has been stolen, right? Someone on social media has posted, a link to your work on a product or in an ad campaign or something like that. The number one don't is don't post about it on social media. Don't complain about it on social media. Don't make public pronouncements about it of any kind until you talk to a lawyer. The reason for that is, unless you just want to complain about it, right? If you just want to vent about it and get sympathy, as you're saying, then that is what you do. You just post about it, and I'm sure your followers will come to your defense. The problem with posting about it before you talk to a lawyer is that your followers are going to start tagging whoever copied you, whatever that company is. That company's social media department is going to see those posts. There's going to be an oh shit scramble there. They're going to start taking down evidence that your lawyer is going to need to see to know exactly what happened. This has happened to me many times where a client, and it's a completely understandable emotional reaction when you see that something that you put all of your heart and your work into has been copied. The first thing you want to do is tell people about it. But there's been so many cases where between that point and the point that the client talked to me, the evidence was just gone, and I didn't know, what the extent of the infringement was. I didn't see the original post. Nobody had screenshotted it. I've had it happen with products where somebody saw a T-shirt with their design on it, posted about it. They were gone from shelves. I couldn't get one. Couldn't see the tag, so I didn't know who the manufacturer was. It happens all the time. So that's my sort of number one don't. Number one do is obviously, talk to a lawyer at least the first couple times that it happens, because they're going to educate you about what you can do. As things progress, as your career progresses, you're going to develop that instinct yourself to know sort of like what to do, what not to do. The first time it happens, like, don't do this on your own, because there's a lot to it. It's emotionally draining. You could end up spending a lot of time and resources and energy and not get any kind of result. Sort of on the other, changing gears here, the number one do is obviously registration, right? And we're talking about, like, why do you register? Why, what are the advantages or disadvantages? Just on a very practical level, if somebody calls me and their work is registered, I'm likely going to take the case. If they call me and the work is not registered, I'm likely not going to take the case. And this goes back to something Josh was saying, which is that there's like an objective value to the work. Like damages in copyright cases, if your work is not registered, you have to figure out, okay, what is the actual damages to you, and that's the most that you can recover. At the most, usually you're going to recover a lot less than that. But the problem is that from your perspective, the damage is huge, because there's this massive company that's stealing your art, they're putting it on products, they're using it without authorization, and they're denying you licensing opportunities, they're creating huge heartache for you. The problem is that value doesn't matter. That's a subjective value to you. All the law cares about is the objective value, which is generally measured by, well, how much of the stuff did they sell? What profits did they actually make? Deduct all these different things that they get to deduct, and the actual damages that you might be entitled to might be tiny. So it's really hard to go down that road, especially if you have to take time out of your day to deal with this. You may have to pay for advice, all of that sort of thing. If you don't have a registration, you very likely are not going to have a practically workable case.
Right. Josh?
Yeah, the other thing that's important is the notion of getting an injunction in copyright. And, your first knee-jerk thing and the reason you would go to social media and start complaining is to try and stop the behavior, right? You see a wound and it's bleeding and you want to staunch it. And in law, that would be an injunction. And you can't get an injunction unless the work is registered. It's just a good thing to do if you want to give a real toolkit to your lawyer.
Yeah.
But I just wanted to say one other thing though, because it's really easy to get for lawyers and business people in the arts to say to practicing artists, you have to do this and this and this and this and this and this. But there's another component to the arts, which is, a sharing culture and a desire to share. And many, many contemporary artists are involved in that culture and participate in that culture. The range of behaviors with respect to how you protect your work, desire to protect your work, and perhaps don't desire to protect your work and instead want it to go out into the world free and clear of the notion of protection, with the internet has become very, very broad. That range is very, very broad. And the law has not met up to it, right? There's been no change in the copyright law of any significance to visual artists in a very long time. And there won't be in the future for a very long time because copyright is so politically fraught now. So, there is this organic world out there, and you're part of it. And so, you have to think about being part of that organism. And sometimes it's good to use the organism in an unprotected way, if you want to get pregnant, for instance. And sometimes you want to be fully protected. And that's a judgment call that you can make, and you should be thinking about making that judgment call. When every single tweet that you write is a copyrighted work. Donald Trump's aren't because he's the president of the United States, and so it's a work of the United States government, so feel free to republish them and mess with them if you want to. But your tweets are copyrighted works, your emails are copyrighted works, your doodles are copyrighted works, all of these things are copyrighted works, and they're all flying around the internet. I took a couple of pictures of and posted them to my Instagram story on my way to get a cup of coffee across the street to show people how hip I am because I'm in Highland Park. And, those are copyrighted works. Those are copyrighted photographs. Do I want people to rip them off? Yeah, I don't care.
But if you did care and you were going to file, aren't there two different kinds, like a $35 file and a $55 registration? Are there two price points, and if so, why? What's the difference?
There are some category price points that are different depending on your category, but basic registration is $35, and then there's accelerated registration, which is what a lawyer is going to require you to do if you didn't register, and they do decide to proceed with a case, and that is, what is that now, $3-something?
It's $800.
$800
now. There are ways to get around that. I
Right.
never tell artists to spend the $800 unless we have to file a lawsuit tomorrow for
Right.
some statute of limitations purpose or something. But they say that so it's $35 and for the basic registration, and it can take them 8 months to process it. If you pay, basically, you bribe the government, essentially, you pay them another $800, they'll process it within 2 weeks. But I found that if you file the $35 one, it rarely takes 8 months, and often I've gotten them back within a week to 4 weeks. So it's just save the money.
Yeah, no, absolutely. Yeah.
You know,
Well, yeah.
kind of based on the whole idea of sharing culture. You know, the other thing, like, and this is just more of an opinion than it is fact. If you do find yourself where, like, you know, you now have a good lawyer who will go to bat for you and stuff like that, don't be the asshole that goes out of your way to say, I'll sue you to every single person that takes a picture of your photo. Like, as an artist, I feel like you have like an obligation to your craft to sort of represent it to the best extent that you can. And you know what, that woman who like took a photo of your piece and has like some photos sitting out like for sale that happens to have one of your murals, like she's probably not the one you want to flex on and be like, I'm gonna get my lawyer, I'm gonna sue you, take this shit down now or I'll rip it off. Like, you know, like focus your anger on people that deserve it. Focus your anger on the people that actually, like any company, any corporation, any ad agency, they know that they're supposed to get clearances on your stuff. Focus it on them. Unleash like the gates of hell on those people. But don't be the asshole that goes around saying I'm going to sue you to every single person that takes a picture of your stuff. It's counterproductive for us as artists, and it's an absolute waste of time for the lawyer unless they're charging you by the hour, in which case the lawyer then will make a shitload of money off of your ignorance.
So, so Logan, you just said something about, you know, corporations know that they're supposed to, you know, do the right thing, right? I'm just playing devil's advocate here for a second. You know, I wonder sometimes, do they fucking know, right? Because like, I think there's...
They get paid to know.
Well, what I'm getting at though is this idea, and Ilya and I talked a little bit about this on our podcast, this wrong-headed idea that because it's public art, you know, it's on the street, you know, that somehow they can use it in their ad campaign without proper permissions or whatever the case might be. I'm thinking of H&M, I'm thinking of Revoke, I'm thinking of that whole bullshit thing that happened. So talk a little bit about that, guys, about, you know, how the H&M thing even happened. Like how a company like H&M, were they so arrogant that they just thought they could get away with it?
You know, first of all, I mean, with street art and graffiti, I mean, it's maybe not so much for street art. I think because it's such a new sort of genre, and the people that kind of got into it all of us kind of got into it for the fun of it, right? Like, you know, we like art, we put out like art on the street, people take pictures of it, you kind of get a kick out of it, maybe you get a show, you sell some stuff, and, you know, you keep moving up this sort of recognition ladder. And at a certain point, you need to stop and go like, oh, well, this is actually a movement now. Like, this is an established sort of thing, and it's not just like other street art like appreciators that are coming in and taking pictures. It's actually people that go like, hey, you got a cool thing, we can make some money off of it. And so like at a certain point you need to kind of stop and recognize you've now entered this, even if you were like anti like establishment, you've now become part of the establishment, even if you don't want to, even if all of your work is about like, you know, fuck the man or whatever else. The fact is, like, when you're doing stuff out on the street, you're looking for the highest visibility, the same way that like any sort of billboard company is looking for the highest visibility like spot. And so when you get to that place, you are now sort of an equal for a corporation, because like you have something that they want. If you're into like getting paid for the work, then they have something that you want. And so any company that's taking photos in front of your stuff, it's because you have an asset that they want to capitalize on. The problem is they don't want to pay the capital.
So Logan, okay, so take us through quickly an example in your own work, in your own career, where you were approached by a brand, a company, and they wanted to hire you. I mean, I saw your amazing mural at Basel in Miami, December for Porsche. That was an incredible work. Kudos, my friend. It was way more amazing than the car itself. But I mean, take us through that. I mean, what do you do as an artist when you're approached by a company like Porsche to make sure that you're protected, that they know what the terms are? I don't know. Take us through that.
Well, every artist has their own limits for things. I mean, as Ron English says, I'm not selling out, I'm buying in. And, you know, for me, like there's certain, And really, the rules that I kind of set for myself in the scheme of things are kind of arbitrary. For me, like I won't work for like cigarette companies, right? Like I won't work for pharmaceutical companies. That's just my thing. Like Walmart, I would never work for. But on the other hand, Target, maybe. So you need to figure out where you kind of stand with stuff. For example, like the piece that he's talking about that was down at Art Basel. Like I did a 26 by 11-foot mural, and that came to me because Porsche approached me and said, well, look, we have this electric car coming out. We want some artwork that kind of complements the car, speaks to like the nature of it. And so I decided to do a mural that I was already going to do. I was going to do it smaller, but I decided to enlarge the size, and it's of Monet's garden in Giverny, based on photos that I had taken when I was there in the last summer. And so for me, it just kind of seemed like an organic extension of what I was already doing. I was going to do it smaller, figure increase the size, put it behind them. I get the artwork back. They don't get any rights, not using ad campaigns or anything else. And it really is like, for me, it felt like a true 50-50 partnership. I walked away with everything I walked into it with, plus I got the recognition and the wall space and had the largest painting that was hanging at Scope that year. And you just kind of need to approach it each time. I don't have like a sales rep that's out there pushing me to companies or corporations. Usually if a company or corporation sees my work fitting into something that they have, because I have a unique style, they'll approach me, and then we kind of talk about it from there. But I think that the organic nature of sort of getting your work out there is sort of key to being happy with what it is that you're doing.
So actually, that's very interesting that you used Monet. That you just took pictures at the garden.
Yeah,
right.
In Giverny, like yeah.
Oh, right. Okay. Because otherwise there'd be like this moral rights claim,
Yeah.
if you use the Monets, right?
Well,
so it's just this. It's like this layer cake of stuff. And since you were doing it in the United States, it's cool. If you had done it in Venice, it wouldn't have been cool.
No. I mean, with my stuff, because it was based off original photos from someone else's garden.
No, no problem at all.
Yeah, I mean, it's Monet inspired. It's
Right.
his garden, but everything else was all mine.
But that's another issue for advertisers and other companies is in a world where appropriation art is so common. If you're dealing with a Shepard Fairey by way of example. All the elements that are brought in by artists now, and with digital tools, how can you not take advantage of that or not know that that's something that you can do? These tools are designed. I mean, I refer to Photoshop and Illustrator as walking, talking infringement tools, and that's what they are. So is Word, so is any email application. You can copy any email you want and republish it. Well, that's a copyright infringement if it isn't your email. And all these tools were produced without any concern about any of that stuff. And so it's really changed the landscape. So clearance is very, very difficult. How does that happen? So, two ways. One, they don't actually tell the lawyer in the company what they're doing. And you have a whole bunch of cool creative people running things, and in many companies, cool creative people have sort of mouthed the actual functional people, and they said we're essentially the client. You got to do what we tell you to do. And the second is that the style of use and appropriation can frequently lead you to not know what's going on, right? And then the style of artists. I mean, there are many street artists who do street art and in fact are dedicating it to the public domain. They have no way of saying it, but that's their intention. And other street artists who don't. There are street artists who really want to protect their mural. There are other street artists who don't mind if someone paints it over as long as it's with something better. I had a whole conversation with a street artist about that the other day. And I said, what's the deal on painting over someone else's work? As long as it's better, I don't care. If it's shit, I get upset.
If you're an artist and you don't think that your stuff is the best, then you're probably not. You shouldn't be putting stuff on the street in the first place. Like I would never be cool with someone painting over my shit. Like I would come to blows with people.
Yeah, there are some artists who are like that. Absolutely,
So
perfectly entitled to be that way.
But if my mural is celebrates, my love for, Daffy Duck, right? It's just amazing, but I want to copyright it. I want to protect it. It's my mural, but it's of Daffy Duck. What hopes do I have?
Well, you can certainly copyright it. You can copyright your additions.
Okay.
And you would be well advised to have a lawyer explain to you how you have to disclose pre-existing works on your application so that your application doesn't end up being deemed fraudulent, because it would be if you failed to disclose that it includes Daffy Duck, which is not something that you contributed, or at least the character. And then you're going to want to have a lawyer take a look at fair use issues, and boy, are those complicated. I mean, fair use is just the most complicated type of legal analysis. It's not to be done off the cuff, and you really actually need an expert lawyer in fair use. You can't just sort of walk in and ask any lawyer to make that analysis for you. It's really tough. Now, that being said, there's a whole world of fair use out there, right? And appropriation art is almost completely resting on fair use. And people like Richard Prince, who at the very top of the food chain, are engaged in that kind of level of appropriation where they're claiming fair use either correctly or incorrectly. So there are people who are willing to play that game, but you better have some good lawyers.
But okay, so at DeviantArt though, I mean, talk about that a little bit. I mean, so many artists are incorporating other people's IP, other corporations' IP. I mean, this must have been a chronic issue for DeviantArt.
Well, it's actually one of the wonderfully organic components of what DeviantArt represents, because on the one hand, you're representing the largest aggregation of people engaged in creating artworks in history, and that's not internet hyperbole, it's actually true, millions of people. And on the other hand, you're representing lots of viewers of art, right, who want access to view works. And in the artist side of it, you're representing a whole bunch of artists who are very actively interested in protecting their work, and a whole bunch of artists who don't care, and in addition, a whole bunch of artists who are appropriating like crazy, and particularly in the area of fan art, right, which DeviantArt has a great deal of. I'm very, very proud of one thing that I accomplished over 18 years at DeviantArt. It's a very long time. We were the first to do all kinds of things. We were the first to allow you to post images with comments underneath them anywhere on the internet. We created the first avatars and identified users by avatar. We do all kinds of things first, but at DeviantArt we did it as open source. Even though I was a lawyer and I said to them, guys, you could make bank over this stuff, we didn't. We did it as open source. As a result, MySpace, Facebook, all these other subsequent users in the social network area adopted and used many of the things we produced without having to compensate us at all. And similarly, the artists on DeviantArt, many of them, have an open source attitude, and particularly fan artists, of course, are interested in being able to work with existing IP, play with existing IP, warp existing IP, integrate existing IP as part of their expression. And the thing that I'm most proud of is in 18 years, we didn't have a single copyright action brought against DeviantArt by anyone, period. And we have now I would think they have over 600 million works. We have 2.1 billion page views a month on this site. It's a huge site with a lot of activity. How did that come about? Well, if someone complained, we paid attention. and we were responsive and tried to be as responsive as possible. I would get a call from a major studio saying, you know, in one instance, we got a call from a major studio. I used to be general counsel at Paramount, so studio people kind of know me. And so I got a call from a major studio saying, hey, you know, we commissioned this artist in Spain to do our poster, and the picture is being released in 2 months, and he's releasing all of his drafts on DeviantArt. What the hell? And I said, well, why don't you tell the artist to take it down? And they said, well, we can't find the artist. What are we supposed to do, right? And so, you know, we would get into that mix, right? And we would help out, and, you know, we would, you know, suspend access to those works until it was resolved, or, you know, do whatever was necessary to do it, because we're part of the world of the arts, right? And there are ways to do that and to engage in that kind of discussion and compromise. Disputes between artists on DeviantArt are obviously very frequent. You know, I posted this, you took it, you're posting it as yours, et cetera. You know, you have people talk to them and interact with them and try and get it resolved, and you can. So, you know, it's a good example of dialogue as a critical tool in the resolution of rights disputes.
Talk a little bit about the resources available to artists. I mean, legal resources. You know, getting back to the fact that, you know, as a small business, you know, we're struggling. It's hard to make ends meet sometimes. You know, your time isn't free. We need to pay you for your expertise. Ilya, how do you work with artists when they call you? You know, with a problem, but maybe not a whole lot of money to go with it?
It depends. Depends on what the issue is, right? So if the issue is that your work is being infringed and you have registered your work, then we can work something out where you're probably not going to end up paying anything out of pocket, and instead do some sort of contingency arrangement where, you know, we get you paid for the infringement and we get a percentage of that. If you don't register your work, we have to do the math and see, is this going to work out? You know, can we actually get you anything that's worth your time and ours? That's a calculation that we have to do. You know, if your work is registered, we generally skip that calculation and say, yeah, you know, we could do this.
Hold that thought. Is his mic on?
No, I can't hear.
Can we?
Sorry.
Sorry. All right. Test. Might be a low battery. Yeah, dead battery.
Thanks.
There you go.
Test. Test.
There we go.
Better?
Start over.
Let's start the whole
Yeah,
thing.
yeah,
over.
yeah,
Let's
yeah. Take it from the
introduce
top.
us again. Yeah.
Yeah.
Do I need to redo that? Or?
Do you want to repeat it? Yeah, let's repeat
All right, sorry about that. Okay. So, if you're calling me with an infringement issue because somebody's used your work without authorization and you've registered it in advance, then you're probably not going to end up paying anything, because we can do a case like that on contingency where we get you paid by the infringer for taking your work, and then we get a percentage of that. If the scenario is that you've been infringed and you haven't registered your work, then we actually have to crunch some numbers and figure out, okay, what are the possible damages that you might be able to get? And frankly, we might not know that information at that stage, because we don't know, you know, let's say it's an infringing product. We don't know how many have been sold, but we have to run these numbers and ballpark it. And, you know, we might not be able to take a case like that on contingency. If your issue is something different, then, you know, that's a conversation we can have. But most of the cases that we do for artists are these copyright infringement cases, and we've done hundreds of them. You know, we do like 50 of them a year, at least. And most artists don't pay us anything because they've registered their work, and we can do this alternative business model with them because we don't want to take money from artists. That's, you know, if you want to support artists, like, you can't take all their money. That's not really supporting them. That's not, you know. So that's, you know, this is why wherever I go, I tell people, register your work. It's really gonna, it's gonna give you so many more tools than if you don't.
Registering your work is kind of like backing up your data. Like, if you lose it once, you always back it up after that. The same way that if someone infringes on your copyright and you don't have it registered, I find that like now I register everything that I do that I possibly can.
There are some free legal services available for artists. So many, you can tell that I'm pretty old. So many years ago, before I went to law school, I helped found something called Bay Area Lawyers for the Arts, which became something called Volunteer Lawyers for the Arts. And there are chapters of Volunteer Lawyers for the Arts, and these are lawyers typically in major law firms who want to do some pro bono work, which means free work, to feel good about themselves and feel good about giving back to the world. There are also lawyers who are willing to trade their services for your work if they really like your work. That's a little bit dicey. That's, kind of gets into all the disputes you end up with galleries when there's, works being traded for other works, which galleries engage in and which very frequently lead to disputes. But there are lawyers who are willing to do that. And, it might surprise you to know that Shepard Fairey got free legal services around the litigation on the Hope poster, at least initially, before he engaged in criminal activity and needed a criminal lawyer. But if there's some sort of like social component to what it is, there are law school clinical programs and other places that might be interested on First Amendment grounds or just on free access grounds or other sorts of grounds in your case and in your situation. So there are opportunities, to get legal services without, the sort of straight up traditional relationship with a lawyer. They're not as functional and as competent as having your own lawyer, because it's hard to access them.
Right. Art schools don't teach this stuff, do they?
Well, I have a son at Art Center College of Design in Pasadena. They have a required course in the business of the arts with like 5 minutes on copyright. And that's considered a very advanced approach. But they do spend more time on accounting, which actually I'm thankful for, because up here we're talking about copyright, and copyright's really highfalutin. I mean, for lawyers, copyright is sort of like the cream, the upper cream of legal representation of artists. I've represented a lot of artists, and very rarely in copyright cases, and most frequently in borderline criminal cases, because artists live on the edge, right? Many artists work in spaces and live in spaces they're not supposed to be doing what they're doing in. I mean, one of my first clients had a printing operation in a loft in New York City and proceeded to use unbelievably carcinogenic stuff, which would create fumes, which would rise in the loft. And he had the misfortune of having a federal judge in a loft about 3 stories up. I mean, that's the kind of stuff that artists get involved in, right? Much more frequently, and where legal services are necessary. And that's run-of-the-mill, go get a lawyer, I guess. But copyright's way the heck up there. If you're in business, you should be worried about taxes. You should be worried about all kinds of withholding and a whole bunch of other stuff. You guys are mostly getting 1099s. You're not employees, and blah, 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 blah. You're going to end up going to jail like actors do for not paying their taxes and that kind of stuff. So, there's a whole panoply of legal issues that artists, that being in the arts present. Right. Like any other business.
So, we're living in a time now, right, where art has gone global. I mean, art's always been global, but street art specifically, right, is a global phenomenon in many ways. I mean, talk a little bit about these, copyright-related matters and issues. If I paint a mural in, downtown London or Paris or Hong Kong, for that matter. I mean, what do I need to worry about when I'm working internationally?
Well, there's no registration of copyright in almost all other territories outside of the United States. But in order to proceed in the United States, you need to register in the United States, even if you're a foreign national. So, still register the work, right? But under international copyright conventions, you as an artist are protected by copyright as you create the mural and as it goes up. Your ability to enforce that right is going to be local to the place where the infringement occurs, where essentially the taking happens. And that could be in Mexico, right? You're going to need a Mexican lawyer.
I think also each country is different, because I know we're in like France, for example. Like if I were to go put something up on the building, nobody can actually take it down and sell it. Even if it was all done illegally, they can't even take pictures of it and publish those pictures, even if my work was created illegally on someone else's property.
That's actually also true here. But yeah, France has moral rights, which are even better. France and Germany have are the two territories with the broadest protection for artists. And that's important to know as an appropriation artist. If you do appropriation art and you start doing that in Germany or France, you're really running a gauntlet.
It's the same, even with you can't take pictures of people and use it in commercial art without their written permission. So any kind of like street photography and stuff like that, you're not allowed to do, from what I understand.
That is accurate, and buildings that are not publicly visible, and a whole bunch of stuff. I mean,
So as a prelude to our next panel after lunch on licensing, talk a little bit about copyright protection, filing for copyright protection vis-a-vis licensing. Can I license an artwork that I haven't filed for protection?
Sure, but if you want to look like you know what the hell you're doing, and if you want to walk into a conversation with Hot Topic or whoever, or a clothing manufacturer or whatever, and you want them to take you seriously, have the works registered before you walk in the door. Be able to reference the work with a certificate of registration number. Those kinds of things make you someone that they should pay attention to. It's like, wearing the right outfit. If you want to prove that you're an artist, you wear the clothes that you painted in or something. I don't know what you do, but, wear a beret or whatever. Have your work copyrighted and be able to sit there and say, hey, this stuff is protected, right? I mean, but yes, you can license. The copyright exists the second you make the work, right? Your work is copyrighted. But to protect it, you got to do this registration thing, certainly in the United States.
To wrap up, I think what I'm hearing you guys say is that to be taken seriously as an artist, to be regarded as a credible professional artist, making filing for copyright protection part of your process truly goes towards elevating your professionalism as an artist, and is a powerful demonstration of your professionalism. Is that correct? Do you agree with that?
Yes.
Yes. All right.
True that. True that, Scott.
True that. All right, guys. How's this panel? Is this good? All right. All right. Thank you, Ilya, Logan, Josh.